warm welcome, everybody. My name is Cornelia Riele. I am the Deputy Head of Section for European Criminal Law in ERA. And in the context of our 30th anniversary and our 30 years and 30 cases, today, we would like to look at the judgment of the Court of Justice of the European Union in criminal proceedings against Hüseyin Gözütok and Klaus Brügge. The judgment of the court was given on 11th February 2003. In these joint cases, the court decided on a reference for preliminary ruling by two national courts, the Higher Regional Court of Cologne in Germany and the Court of First Instance of Vern in Belgium. The reference referred to the interpretation of Article 54 of the Convention implementing the Schengen Agreement. Article 54 of the Convention says that a person whose trial has been finally disposed of in one contracting party may not be prosecuted in another contracting party for the same acts, provided that if a penalty has been imposed, it has been enforced, is actually in the process of being enforced, or can no longer be enforced under the laws of the sentencing contracting party. The facts of the cases in a nutshell entailed that the criminal proceedings against Mr. Gözütok and Mr. Brügge were discontinued by the national prosecution offices after they had paid a fine that had been imposed by prosecution officers. Hence, under the national laws, further national prosecution was barred without any further judicial decision required. However, in both cases, the prosecution offices of other member states had initiated criminal proceedings against Mr. Gözütok and Mr. Brügge for the same facts. Therefore, the national courts of these member states referred to the Court of Justice asking whether the ne bis in idem principle laid down in Article 54 of the Schengen Convention also applied to procedures whereby further prosecution is barred. In answer to this question, the court ruled that the ne bis in idem principle laid down in Article 54 of the Schengen Convention also applied to procedures whereby further prosecution is barred, such as the procedures at issue in the main actions, by which the public prosecutor of a member state discontinues criminal proceedings brought in that state without the involvement of a court, once the accused has fulfilled certain obligations and, in particular, has paid a certain sum of money determined by the public prosecutor. Therefore, the person concerned must be regarded as someone whose case has been finally disposed of under the scope of Article 54. In addition, once the accused has complied with the procedure, so for instance paid, the penalty imposed must be seen as having been enforced for the purposes of Article 54. The fact that no court is involved in such a procedure and that the decision in which the procedure culminates does not take the form of a judicial decision does not cast doubt on that interpretation, since such matters of procedure and form do not impinge on the effects of the procedure. In those circumstances, there is a necessary implication that the member states have mutual trust in their criminal justice systems and that each of them recognizes the criminal law in force in the other member states, even when the outcome would be different if its own national law was applied. We would now like to look at the impact of this judgment on the development of European criminal justice. For this, I would like to warmly welcome Professor André Klipp. Professor Klipp is Professor of Criminal Law, Criminal Procedure, and the transnational aspects of criminal law at the University of Maastricht. He is also judge at the Court of Appeal of Hertogenbosch in the Netherlands. And it is a particular pleasure to have him here with us today, as at the time of the case in 2001, he had provided an advisory opinion to the Higher German Court of Cologne on the interpretation of the principle of ne bis in idem in the Schengen Treaty. Professor Klipp, why is this case important in shaping the case law regarding the principle of ne bis in idem?
Yeah, the case is very important, but I must also say I very much enjoy that you've invited me to say a few words on this case. For more than 20 years ago, I was invited by the Oberlandesgericht Köln, the Court of Appeal in Köln, that referred the case to the Court of Justice on this matter, and to give it a legal advisory opinion on what exactly is the position and the Dutch law when it comes to prosecutorial decisions to finalize the case. And this is exactly the point. It is a prosecutorial decision to come to end to the proceedings, not a court decision. And if you look at the Schengen Treaty, you will see that the Schengen Treaty referred to court decisions. And my legal opinion stated that on the interpretation of the law, the explanation, the meaning of the treaty is very, very clear. So I gave a legal opinion explaining the terms of the treaty. And in my research, it became clear that in the negotiations of the treaty, the Schengen Treaty, the Netherlands had proposed to the other parties to have prosecutorial decisions included in the recognition as a non-bis in idem factor. And all the other parties rejected that. Well, on the basis of interpretation and explanation of international law treaties, it is then subsequently very clear that it is not included. So to the surprise of many, the court said, we do include it. So the court used a different interpretation than international law. And the court gave its first recognition to a prosecutorial decision that made an end to the proceedings. And that is where the importance is, both on the recognitions as on the interpretation of the law.
Why is this case in general important to understand how the court interprets the law?
Well, the interpretation of the law refers to the element that I just mentioned. The court does not use the general rules of explaining of interpretation that are applicable under international law. That means that the legal history may not be the most decisive factor. What the court did in this specific case is teach us a lesson. Teach us a lesson in the sense that it said, if you interpret a treaty that functions in the area of freedom, security, or justice, you must take that area into consideration. And that means that the court focused, zoomed in on the very fact that those persons that profit from a so-called prosecutorial decision to impose a fine, that those individuals are individuals that commit minor offenses. And those that commit minor offenses are also people that profit from the free movement rights that individuals have within the European Union. And the court said, if we limit the recognition and the benefits of Article 54 Schengen, the recognition and the impediment for a second trial to court decisions only, it would have the result that only those that have committed serious offenses would profit from it. And those that commit minor offenses that do not lead to court decisions and do not lead to imprisonment sentences would not profit from that. And in that context, the court gave an additional, and I would say almost overriding argument to give a prosecutorial decision the benefit similar, on the same level as a court decision.
What was the impact of Gözütok and Brügge on the mutual trust and mutual recognition in criminal matters between the member states of the European Union?
Well, concerning mutual trust, I would say that it was one of the first decisions in which the court mentioned or gave the member states the warning, mutual trust has a meaning in criminal matters. Mutual trust means that you have to recognize things that you would personally in your state have organized in a different way. So you must recognize decisions, you must recognize procedures that could possibly not have taken place in your country in this way. You must recognize it because you must have the trust that the other member state has organized its matters in an appropriate way. So this is the first decision in which the court made that clear. And for this concrete member state, Germany, it meant that it had to recognize prosecutorial decisions. And the German law, this is simply not possible. But that is not the matter. That is not the issue. It is possible under Belgian law and under Dutch law. And because of the fact that other member states have recognized this, the third member state, Germany, must also recognize this. So the basic rule deriving now from mutual recognition is that you must recognize things even if they are made in a different way than you would ever do yourself.
Why was Gözütok and Brügge groundbreaking with regard to the implementation of the Schengen acquis?
Well, it was not only the first decision, the first major decision for the Schengen implementing convention, it was also a decision that triggered a whole series of other Nebis in Idem decisions. Gözütok Brügge was the first one, but it was followed up with decisions on other aspects of the Nebis in Idem issue. So in the years after 2003, we saw several decisions on Nebis in Idem taking different elements. So for instance, the court gave a definition of what exactly is the same act. It gave definitions on the relationship between criminal proceedings and administrative proceedings. And the impact was quite impressive to the extent that the definitions that the court used, the court in Luxembourg, those definitions were also subsequently used by the European Court of Human Rights in Strasbourg. So in that sense, the 54 Schengen provision had a huge impact also on the human rights provisions at the Strasbourg Court.
Professor Klipp, are there any problems left today, practical or theoretical, on the implementation of the principle of nebis in idem in such procedures that do not require participation of a court or do not accumulate to the form of a judicial decision?
Yes, I would say there are still two major issues on that need a solution. And whereas the Gözütok Brügge case dealt with a positive prosecutorial decision and gave an answer to that, there are also negative prosecutorial decisions. And with a negative prosecutorial decision, I mean the decision taken by a prosecutor not to bring charges, not to conclude a fine with the suspect person. Also, these decisions may end in member states the proceedings and may make it impossible to further continue proceedings. So a prosecutorial decision on the basis of the law of some member states is the end to the proceedings. Personally, I would say it is in the logic of the case law of the court on nebis in idem that such a negative prosecutorial decision would also get the same recognition and will also bring an end to the proceedings elsewhere in the European Union. But the court hasn't said so, so we still don't know whether my view will be also the view shared by the court. So we have to wait for that. The second issue on which there is still something that must be clarified more precisely than it is now relates to the use of nebis in idem as a ground for refusal in European arrest warrant proceedings. As you may know, a European arrest warrant in principle must be followed up to because it is based on the principle of mutual recognition. However, it can be refused when the member state, the executing member state, can invoke a ground for refusal. One of those grounds is nebis in idem. Well, given the fact that the court has stated that nebis in idem is an autonomous concept under union law, it would have the consequence that if one member state would label this, the situation as a situation of nebis in idem, that it would not only mean an end to the EAW proceedings, but that it would also mean that the issuing member state would no longer have a case. So it is the transnational implication of a finding of an individual member state that is still to be decided by the court. And again, it would be very interesting to hear what the position of the court is. And it is necessary because we do know that in the practice of European arrest warrant proceedings, some requested person travel from one member state to another, and their surrender is refused every time. But it would be more practical for their day-to-day business if the refusal by one member state has consequences for other member states as well. So that is the second point on the wish list.
And finally, how did the judgment of the court help in creating an area of freedom, security, and justice?
Well, I think the court emphasized very much the area dimension of the European Union, and the area of freedom, security, and justice was very much emphasized by this court decision. In other words, the legal relationship is no longer a typical bilateral relationship between one member state asking another member state to do something in which the individual citizens doesn't play a role. That is no longer the case. What we see in this case, recognized, is that there is a triangular relationship. So we have two member states and we have an individual citizen of the European Union that is entitled to certain rights and can invoke these rights. And I think that is the major contribution of the court that started with this famous Gözütok and Brügge case in 2003.
Thank you very much for your time.